We had that huge oral argument yesterday in front of the United States Supreme Court in the Mexico versus Smith & Wesson case. I promised you I'd play you sort of the highlights so you can see the sort of issues that Second Amendment lawyers have to confront when dealing with judges. And it's quite interesting, the back and forth between the Supreme Court justices on the one hand and the lawyers for the parties on the other hand. You're not going to want to miss this right here and right now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America today. Thank you for your support of the 2025 Gundies Awards. Again, I know I could not have done it without you, the fans, the supporters, the subscribers, and the people that voted me for that award, and I do really appreciate that great privilege and honor. All right, folks, so we had a huge Supreme Court oral argument. 9 justices heard, 2 lawyers argued for almost 2 hours in the case of Mexico versus Smith & Wesson, among others. This dealt with a lawsuit by the government of Mexico against the American gun industry, claiming that the American gun industry was somehow complicit with the Mexican cartels by supplying guns to so-called rogue gun retailers, who in turn sold their guns to straw purchasers, who in turn, apparently, according to the allegations, somehow got these weapons into the hands of the Mexican cartels in Mexico, who then committed murder and mayhem, and thus the American gun industry should pay the bill of the government of Mexico. And by the way, as you know, the worst court in America for our Second Amendment rights is the United States Court of Appeals for the First Circuit in Boston, Massachusetts. And lo and behold, and totally by coincidence, I'm sure, the government of Mexico sued in that court's jurisdiction. So anyway, the lower courts were going to allow this case to go forward because that's what you'd expect out of Boston courts. And the U.S. Supreme Court stepped in, granted cert, and heard oral argument yesterday. And as I told you before, I think the good guys are going to win this case. Smith & Wesson and the other gun industry defendants are going to win the case. As to how they're going to win and the rationale by the Supreme Court, that's an open question. I have my concerns that the holding by the Supreme Court will be narrower than it should and thus not be as helpful down the road in, for example, lawsuits against gun companies in state courts as opposed to federal courts. Now, with this said, there was some great back and forth, and I want to play you some clips directly from the Supreme Court oral argument. I think you will enjoy this. To begin with, let's look at the opening statement by the Second Amendment attorney, No Francisco, who was the Solicitor General of the United States under Donald Trump, the first 2016 to 2020 term. Let's see what No Francisco has to say about why his client, Smith & Wesson, in the gun industry should win this case.
Mr. Chief Justice, and may it please the Court. Mexico asserts that American firearms companies are responsible for cartel violence ravaging Mexico. Its theory is that federally licensed manufacturers sell firearms to licensed distributors, who sell to licensed retailers, a small percentage of whom sell to straw purchasers, some of whom transfer to smugglers, who then smuggle them into Mexico, hand them over to cartels, who in turn use them to commit murder and mayhem, all of which requires the government of Mexico to spend money. Needless to say, no case in American history supports that theory, and it's squarely foreclosed by the Protection of Lawful Commerce in Arms Act. As to proximate cause, this court has repeatedly said there must be a direct relationship between the defendant's conduct and the plaintiff's injury. But no such relationship exists if plaintiff's injury is caused by multiple intervening independent crimes committed by foreign criminals on foreign soil to inflict harm on a foreign sovereign. As to aiding and abetting, Mexico doesn't identify a specific crime, criminal, or criminal enterprise that defendants supposedly helped. Instead, it asserts that defendants are liable for every illegal sale by every retailer in America, because they know that a small percentage of firearms are sold illegally and don't do more to stop it. Again, no case in history supports that theory. Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash. The First Circuit gravely erred in embracing that implausible theory and should be reversed.
Powerful opening statement by the attorney No Francisco for the gun industry, but then he goes on and really ties it in at the end to why this matters so much for the Second Amendment specifically. And in addition to that, he talks also about crazily enough, a situation where there was 3 pistols with Spanish language on it, and the government of Mexico is trying to say that an American company producing the firearms with Spanish language on it, or Spanish sayings on it, somehow caters to the cartels. No, Francisco does not accept that argument. And here's what he has to say about that and the importance of this case to the U.S. Constitution and the Second Amendment itself.
My friend also talked about 3 pistols sold by Colt with Spanish-named firearms. The notion that selling a Spanish-named firearm is what gives rise to joint purpose with cartels under the aiding and abetting statute is as wrong as it is offensive. There are, after all, millions of perfectly law-abiding Spanish-speaking Americans in this country that find those firearms very attractive, and making those firearms available cannot possibly cross the line into aiding and abetting liability. But even if it could, the notion that selling 3 Spanish-named pistols is the proximate cause of cartel violence in Mexico is frankly absurd, and I don't think it comes even close to establishing Twombly's plausibility standard. My final point is just to step back and talk about what PLACA was really about. At the end of the day, PLACA is about protecting Second Amendment rights. It's not just about protecting the manufacturers, the distributors, and the retailers, but it's protecting the right of every American to exercise their right under the Second Amendment to possess and bear firearms. That right is meaningless if there are no manufacturers, retailers, and distributors that provide them in the first place. We ask that you reverse.
Well, of course, this is an American litigation, which means there's back and forth. Now, the attorneys for Mexico had much to say. They articulate a theory of liability that says, indeed, you can hold American gun companies liable for the damages inflicted by gun-related violence by criminals and cartel members in the country of Mexico. Here was their opening statement in favor of the government of Mexico.
Mr. Chief Justice, and may it please the Court, Mexico's complaint pleads that petitioners aided and abetted violations of specific federal gun laws and that those violations proximately caused Mexico's harm. That satisfies PLACA's predicate exception. First, the complaint details that petitioners deliberately supply the illegal Mexican market by selling guns through the small number of dealers that they know sell a large number of crime guns and who repeatedly sell in bulk to the cartel traffickers. Petitioners' arguments ignore these allegations. Next, as the Court said in Twitter, an aider and abetter is liable for harms that were a foreseeable risk of that violation. That framing, foreseeable risk, is the proximate cause question. As this Court put it in Bank of America, does the harm alleged have a sufficiently close connection to the conduct the statute prohibits? The answer is yes. The laws broken here are designed to keep guns out of criminals' hands. Those violations put guns in criminals' hands, and those criminals harmed Mexico. Petitioners' arguments would rewrite PLACA and proximate cause law far beyond this case. Petitioners argue that independent criminal acts sever the causal chain. But an independent act, criminal or not, only breaks the causal chain if it is not foreseeable. These acts were foreseeable. Petitioners argue that Mexico's injury is not direct, but their directness argument borrows from cases involving indirect victims. Mexico is not an indirect victim. We are here at the beginning of this case. This Court need not vouch for Mexico's allegations, but it must assume they are true. And the issue at this stage is not whether every aspect of Mexico's complaint survives, but whether any of it clears the predicate exception. Mexico should be given a chance to prove its case. I welcome the Court's questions.
Well, those are interesting opening statements and opening comments by the attorneys, but of course the justices get involved as well. And I think the most entertaining question of the day or observation of the day was by none other than New Yorker Justice Sotomayor, who asked about the importance of, ready for this, folks? I kid you not, you'll hear it for yourself, erasable serial numbers on guns. Have you ever heard of an erasable serial number? Well, you're about to right now.
It's foreseeable.
Now, can I
risk.
go back to what's troubling me? You have the manufacturers aiding and abetting, in your theory, by producing guns that are singularly attractive to the cartel. because they're designed in a particular way that cartel members like because they're showy. They're making erasable serial numbers, which obviously are attractive to criminals because every criminal would like to erase the serial number if they can.
Well, that's crazy stuff there. But nevertheless, let's listen to this very interesting back and forth between Justice Clarence Thomas and the Second Amendment lawyer Noel Francisco arguing for Smith and Wesson, where basically Clarence Thomas says, walk us through all the different causal connections that have to be satisfied for Mexico to win this lawsuit, all the intervening events. Just walk us through how it works in the American gun industry to make a gun and then get it sold in the marketplace. Kind of like basically Clarence Thomas say, walk us through the womb to tomb of a firearm in terms of commerce. And this is the back and forth between Justice Thomas and Smith and Wesson's lawyer right here.
Mr. Francisco, in direct sales, there was exactly that, a direct sale to a doctor. And the seller worked closely with the doctor to work around the limitations. In your brief, you summarized the chain that you've mentioned or alluded to a number of times. Mm-hmm. Would you just list the chain for our benefit?
Sure. Starts out with a licensed manufacturer, a manufacturer that the federal government says is allowed to make firearms. It then distributes its legal firearms to licensed distributors who the federal government says are allowed to distribute them. They then sell to licensed retailers that the federal government says are allowed to retail. Those retailers, some very small percentage of them, unknown number, but some small percentage of them, transfer those firearms illegally to straw purchasers. The straw purchaser then hands it over to the actual purchaser. You then have a smuggle across an international border, yet another violation of law. The smuggler then presumably gives it to the cartels who are illegally possessing the firearm in Mexico under Mexican law, as my friends have described it. Then the Mexican cartels engage in murder and mayhem against the good people of Mexico, all of which in turn causes the Mexican government to have to spend money to respond to that murder and mayhem. With respect, there's not a single case in history that comes close to that. They don't even cite cases that find a manufacturer, I think, ever liable for the unlawful criminal misuse of its products, other than the cases that PLACA was meant to prohibit, and perhaps other than the Avis case, the Florida Supreme Court case. But they certainly don't cite anything that comes close to that chain of causation, which is more extreme than the cases that PLACA was meant to prohibit.
Well, again, that's a pretty attenuated chain of causation, but, unfortunately, I'm concerned the Supreme Court's not going to rule on causation per se. They're going to laser focus on the aiding and abetting liability, which is a much more narrow holding that we in the Second Amendment community would really want. And to illustrate my concern here is a very pointed question by Justice Amy Coney Barrett to the Second Amendment lawyer Noel Francisco, specifically saying, isn't it a fact that if we rule for your client on aiding and abetting liability, we don't need to get involved with this proximate cause issue, which, of course, frankly, from a Second Amendment point of view, we really only care about winning proximate cause because then we can use that precedent in favor of proximate cause, meaning there is no causal connection that can be established between a gun company selling guns and the criminal misuse many, many steps down the road, because that is the basis of all these lawsuits all around America in state courts under state law. And we needed a proximate cause victory in this case to knock those out, but I'm not sure we're going to get it. And here's Justice Barrett clarifying that if the Supreme Court issues a ruling on aiding and abetting liability under federal law, this case is disposed of without them having to deal with the question of proximate cause.
Just one question. Is there any reason for us to reach the proximate cause question if we conclude for aiding and abetting that you win?
If you rule for us on aiding and abetting, that will completely dispose of the case. The reason to also address proximate cause is because it's an extraordinarily important issue that I think applies in many different contexts, which is why there's such a broad range of amici in this case that go well beyond the firearms industry. So while you could completely resolve it on aiding and abetting, I would urge you to address proximate cause as well.
So again, I think that does indicate where the Supreme Court is going, which I am not super happy about. I'm happy that they're going to win this case. I'm not happy with how I think they're going to win the case because I don't think it's going to have a lot of beneficial ripple effects around this great country, but we will see what ultimately happens. Now, with that said, Justice Samuel Alito, one of the smartest justices of all time on the Supreme Court, actually had a great question here where he's asking the lawyer for Mexico about, well, can't we now sue Mexico in American courts? In other words, why, if Mexico can come to the United States to sue gun companies over things that occur in Mexico, maybe some states in the United States can sue Mexico and the government of Mexico in the United States in the same way. A very interesting observation by Justice Sam Alito here, and see what the government of Mexico's lawyer has to say in response.
There are some very interesting technical legal issues in this case, proximate cause, aiding and abetting, how much do you have to plead in a complaint, and you and Mr. Francisco have briefed and argued those very well. It's very helpful to the court. I just thought I would ask you a question that may be on the minds of ordinary Americans who hear this argument or learn about the case. Mexico says that U.S. gun manufacturers are contributing to illegal conduct in Mexico. There are Americans who think that Mexican government officials are contributing to a lot of illegal conduct here. So suppose that one of the 50 states sued the government of Mexico for aiding and abetting illegal conduct within the state's borders that causes the state to incur law enforcement costs, public welfare costs, other costs. Would your client be willing to litigate that case in the courts of the United States?
Justice Alito, I think we would have to accessorize that hypothetical with what I assume are a lot of the things that are built into it, that there are no forum and venue questions, and that the kinds of allegations are specific and talk about specific harms to the state. So
well, would your government say, whoa, your client say, whoa, sovereign immunity, you can't sue us on this?
Well,
would you be willing to litigate all the doctrines that would apply if the government of Mexico were not entitled to sovereign immunity?
So, Justice Alito, under FISA, of course, Mexico is entitled to come in, and the petitioner's own amici point this out, to come into this case just like any other litigant. There are, of course, differences if Mexico is brought in as a defendant. So I can't and certainly don't feel comfortable giving away things like sovereign immunity on behalf of the government of Mexico.
Well, I understand that. So the argument basically is it's a one-way street.
No, Justice
the government
Alito,
of Mexico can sue U.S. manufacturers here for harm caused in Mexico, but one of the states here can't sue the government of Mexico for harm caused in the United States.
I don't think it's entirely accurate to call it a one-way street. And if the street is one way, it's because FISA and other decisions from this court have said that when a sovereign comes into this court as a plaintiff, it is treated exactly like any other plaintiff, no more and no less.
Thank you.
Of course, there's always a little bit of humor in these Supreme Court cases, with logic, of course. And I think this was a very good question by Justice Sam Alito, where he's basically saying, so what you're saying is that these gun retailers along the Mexican-American border tend to have more guns found in Mexico than, let's say, a gun retailer that sells guns in, I don't know, Vermont, Montana, whatever, because they're so far away from the border. So then Justice Alito takes us to its logical next step and says, well, let's get this straight. If you're saying that if I know selling guns to retailers at the border gives rise to more guns to Mexico, well, how do we deal with a scenario dealing with a beer company, an alcohol company that sells into a college town where there's a lot of underage drinking versus, let's say, selling alcohol to a town or a city that doesn't have as many colleges? A very interesting observation by Justice Alito here.
What if a beer — I'm sorry, I cut off your sentence. Did you? What if a beer manufacturer knows that the per capita beer sales in a small college town are, 50 times more than another town without a college there? Is that enough?
I don't think that alone would be enough. I mean, you do have allegations in this complaint that the number of dealers that have arranged themselves along the border of Texas and Arizona of Mexico are vast. I don't think that itself would be enough. It would be, you know, the dealers are there, you know what they're selling, you know who the bad apple dealers are, because we're not talking about every dealer in the country. We are talking about a small percentage of retailers responsible for about 90% of the crime guns that are found. Those retailers in that college town, if you plug in that hypothetical of Budweiser, and Budweiser was marketing in with some kind of, best first-year homecoming ever, then you would again have the problem. But you'd have to have each of those specific allegations in the complaint that you have here.
So there you have it, folks. Some back and forth, some interesting observations by the U.S. Supreme Court and the lawyers in this case. Again, I would always like to play these things for you because it's important for you to see what really goes on in America's courts, the good and the bad and the ugly. Some positive things, because again, I think Smith & Wesson and the gun industry is going to win this particular case. That's great. But again, my concern is the way they're going to win may not produce the positive ripple effects that I would like to see for the Second Amendment community and in favor of the American gun industry, which we need to have a thriving Second Amendment community, because most people buy guns from gun stores made by gun companies. And if you do away with them or hurt them or drive their prices up, it's going to impact we American gun owners and our rights. So there you have it, folks. Hope you learned something here today. Make sure you subscribe both on YouTube and Rumble. Don't forget to follow me on X at 4 Boxes Diner. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.